It is 6 in the morning. You are still in bed. Your phone buzzes. You pick it up, squinting at the screen, and there is an email from USCIS. Your hands go cold. Your stomach drops. The subject line reads, "Notice of Intent to Revoke." You do not even know what that means, but you feel it. Deep in your chest, you feel it. You have been waiting 3 years for your green card, 3 years of paperwork, attorneys, fees, stress, sleepless nights. Your children were born here. Your spouse works here. Your entire life is planted in American soil. And in 14 words on a tiny screen, everything you built feels like it is about to collapse. You sit up. Your hands are shaking. You do not know whether to call your lawyer, call your spouse, or cry. And here is the terrifying part. Millions of immigrants are waking up to exactly this kind of moment right now, and most of them are making the same 3 fatal mistakes that could end their cases permanently. This is not a drill. This is not a rumor from someone on Facebook. What I am about to tell you in the next 12 minutes could be the difference between keeping your green card and losing everything you have worked for. Stay with me. Do not click away. This update is urgent, and it is for you. Right now, in 2026, the United States government is moving forward with a series of green card restrictions that are catching legal permanent residents and adjustment of status applicants completely off guard. We are talking about new public charge enforcement measures, tightened continuous residence requirements, expanded grounds for green card revocation, and accelerated scrutiny of naturalization applications. These are not proposals. These are active policy shifts being implemented by DHS and USCIS right now. And the problem is not the policies themselves. The problem is what immigrants do not know about them. The problem is the gap between what is actually happening inside the federal system and what people are hearing from neighbors, from Facebook groups, from TikTok videos posted by people with no credentials and no legal training. That gap, that silence between truth and rumor, is where families get destroyed. Let me show you exactly how the trap works. When USCIS sends a request for evidence or a notice of intent to revoke, most immigrants panic and do one of 3 things. First, they ignore it. They assume it is a mistake. They think the government will fix it. It will not. Second, they call a notario. In many communities, there are people who charge money, sit behind a desk, call themselves immigration consultants, and have absolutely no legal authority to represent you before any federal agency. They fill out forms incorrectly, give advice that is not based on law, and when things go wrong, they disappear. The third thing people do is flood social media asking strangers for advice. And this is where it gets dangerous, because someone will respond. Someone always responds. They will say something like, "Oh, that happened to my cousin, just ignore it," or just send them a letter back saying you disagree. And that person, with complete confidence and zero accountability, will set your case on fire. Here is what makes 2026 especially dangerous for green card holders. Under recent DHS enforcement guidance building on executive directives issued in early 2025 and extended into this year, USCIS has been directed to increase scrutiny on several specific categories of green card holders. This includes individuals who received their green card through adjustment of status and have had any period of unlawful presence, individuals whose sponsoring employers are no longer in business, individuals who have traveled internationally for more than 6 months in a single trip without a re-entry permit, and individuals who have received certain public benefits after their green card was approved. The public charge ground, which is codified under Section 212A(4) of the Immigration and Nationality Act, has been reinterpreted in several internal USCIS policy memos. The current administration has instructed adjudicators to apply a broader totality of circumstances test when reviewing naturalization and certain green card renewal applications. This means things that were previously considered harmless, like a short period of Medicaid enrollment or a temporary lapse in employment, are now being flagged and used as grounds to send additional requests for evidence, or, in more serious cases, to initiate revocation proceedings. And here is the government trap that almost nobody is talking about. When you receive a request for evidence, At the very bottom of that document, USCIS lists a response deadline. Most people read that deadline and assume it is fixed. They assume they have exactly whatever number of days is printed on that page to respond. What they do not know is that under 8 CFR 103.2b, 8, USCIS is required to give applicants a reasonable opportunity to respond, and in certain circumstances, applicants can request an extension of the response deadline. Most immigrants never do this because they do not know it is an option. They rush to gather documents, they submit incomplete responses, and USCIS denies their case because the evidence was insufficient, not because they were ineligible. The denial was preventable. The case was winnable. But they did not know the rules of the game they were playing. That is the trap. The government does not explain every option you have. It is your responsibility to know, which is exactly why you are here right now. Now let me give you the legal shield. Let me explain what actually protects you, because the law does protect you, and understanding it is the most powerful thing you can do. Under the Immigration and Nationality Act, specifically INA Section 246, USCIS has the authority to rescind a green card within 5 years of it being granted if it was improperly issued. However, rescission requires a formal notice, a right to a hearing, and proper procedural steps. It is not a sudden, overnight cancellation. You have rights in that process. You have the right to present evidence. You have the right to legal representation. If USCIS skips any of those procedural steps, the rescission can be legally challenged. That is federal law. Additionally, under the Fourth Amendment of the United States Constitution, you have the right to be free from unreasonable searches and seizures. This applies to immigration enforcement at your home. ICE agents cannot enter your residence without a judicial warrant signed by a federal judge. An administrative warrant issued by USCIS or ICE itself is not sufficient for forced entry. You do not have to open that door. You have the right to remain silent. You have the right to speak with an attorney before answering any questions from any immigration officer. These are not technicalities. These are constitutional protections that belong to you, whether you are a citizen, a green card holder, a visa holder, or an undocumented immigrant. The Constitution does not only protect citizens, it protects persons. And you are a person. Now let us talk about what social media is getting catastrophically wrong, because the misinformation right now is at a level I have not seen in 6 years of doing this work. I need you to hear me clearly on each of these points. First, there is a rumor spreading widely on TikTok and in WhatsApp groups that the government is automatically revoking green cards for anyone who has received food assistance or Medicaid since 2023. This is false. USCIS has not issued any blanket revocation policy based solely on benefit receipt. What has changed is the scrutiny applied during certain applications, specifically naturalization and certain re-entry situations. Existing green cards are not being mass revoked because of benefits. Do not let that rumor push you into making panicked decisions that actually hurt your case. Second, many people are being told by notarios and community consultants that they should file a second green card application to reset the clock on scrutiny. This is not only wrong, it is dangerous. Filing a duplicate application without proper legal basis can be treated as misrepresentation, which is a far more serious problem than whatever issue you were trying to avoid. Third, there is widespread confusion about the travel rule. People are being told that leaving the United States for any reason more than once in a year can trigger abandonment of residency. This is also inaccurate. The abandonment standard under INA Section 101A, 13C, requires evidence of intent to abandon residency, not simply a count of trips. Frequency of travel alone, without other factors, is generally not sufficient to trigger a finding of abandonment. However, single trips exceeding 6 months without a re-entry permit do raise a presumption, and trips exceeding 1 year can break continuous residence for naturalization purposes. That is the real rule, not the rumor. The real rule from the actual law. Now I want to give you your action plan. I want to walk you through exactly what you need to do, starting tonight, to protect yourself under the current enforcement environment. These steps are not optional. They are your defense strategy. The first thing you need to do tonight is pull your I-94 travel record. Go to the CBP I-94 website, which is i94.cbp.dhs.gov, enter your information, and download your official travel history. Check every entry and exit. Verify that the dates are accurate. If you see a discrepancy, that discrepancy needs to be addressed with legal help before it causes a problem. Do not wait until USCIS finds it first. The second step is to gather your tax records. Pull your IRS tax transcripts for the last 5 years. You can request these for free at irs.gov using the Get Transcript tool. If there are years where you did not file, or years where your income looks inconsistent with your immigration status, make note of those. These records are among the first things USCIS will ask for during any enhanced review, and having them organized in advance puts you in control. The third step is to document your continuous residence. This means collecting evidence that you have been physically present in the United States consistently. Utility bills, lease agreements, bank statements, employer records, school enrollment records for your children, anything with your name, address, and a date. Organize these documents by year and keep them in a folder, physical or digital, that you can access quickly. The fourth step is to review your public benefits history. If you or anyone in your household has received benefits such as Medicaid, SNAP, Section 8, or cash assistance, document the dates of enrollment and the dates of any termination. Understand what you received and when. If you received benefits during a period when you were a green card holder, speak with a qualified immigration attorney about how that might appear in the context of your current situation. Not every benefit use is a problem, but understanding your own record is essential. The fifth step is to verify your employer's current status if your green card was employment-based. If your sponsoring employer has closed, been acquired, been subject to any legal action, or if your job duties have significantly changed since your green card was approved, this is a potential vulnerability in your file. An employment-based green card holder should be able to demonstrate continued intent to work in the qualifying position, particularly within the first year of receiving the card. If your situation has changed, get ahead of it. Do not wait for USCIS to ask. The sixth step is to locate a qualified immigration attorney now, before you have a problem, not after one arrives. Find someone licensed to practice immigration law, a member of the American Immigration Lawyers Association, someone with verifiable credentials. Have their contact information saved in your phone? Know what your intake process would look like. In an emergency, the worst time to find legal help is in the middle of the emergency. If you are ever stopped by an immigration officer and asked about your status, your travel, your employment, or your residence, you have the right to say, "I am exercising my right to remain silent, and I would like to speak with an attorney before answering any questions." Say those words calmly, say them respectfully, and then say nothing else. You do not need to explain. You do not need to justify. Those 14 words are your shield. Memorize them. My name is James. I am a senior immigration analyst with 6 years of experience, and on Immigration News Today, I do not give you opinions. I give you the survival strategies that keep families together. The information in this video is based on current federal law, USCIS policy guidance, and the Immigration and Nationality Act. It is not a substitute for personalized legal advice, and I always encourage you to work with a licensed attorney for your specific situation. But knowledge is the first line of defense, and you came here to be defended. Immigration rules change overnight. A memo released on a Tuesday can change the way your case is reviewed by Friday. I have created a WhatsApp community specifically so that you receive those alerts before they become crises. The link is in the description below this video. Join now, it is free, and it could save your status. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration News Today right now and turn on notifications. Staying informed is no longer optional. It is essential. I am James. Protect your status, protect your family. I will see you in the next update.